Contrasting some of the rules of the California Evidence Code with the federal rules of evidence. In California, a fact must be in dispute in the case to qualify as relevant. But in the federal court, a fact of consequence in the case can be sufficiently relevant for admission. Personal knowledge of the witness is a conditional relevancy question for the trier of fact, the judge or jury in California. But under federal rules, personal knowledge is a preliminary facts question for the judge. Some evidence is inadmissible on grounds of public policy. Subsequent remedial measures evidence is admissible in the federal rules as evidence of a defect in a product, but it's inadmissible in strict product liability cases in California. In contrast to the federal approach, evidence of subsequent remedial measures is allowed only in cases involving negligent or culpable conduct in California. California is more strict than the federal rules when dealing with evidence of offers to pay medical expenses. If the statement, "I apologize for causing the crash, let me pay your medical costs," is presented as evidence, both sentences would be inadmissible in California. Whereas the first sentence, "I apologize for causing the crash," would be admissible in federal court. California also protects expressions of sympathy. Where there's no similar federal rule, expressions of sympathy are inadmissible in California on grounds of public policy. Character evidence is generally inadmissible to prove the accused acted in conformity with such character on the occasion in question. The evidence of the character of the victim is admissible under the victim exception, but only opinion and reputation evidence of the victim's character is admissible in federal court, where specific instances, examples of the victim's character, are admissible in California. Also, the California rule allowing prior acts of child molestation and sexual assault is narrower than the federal rule in that it's limited to criminal cases and is not allowed in civil cases. But the California rule is broader than the federal counterpart in that it extends to possession of child pornography, domestic violence, abuse of an elder, as well as child molestation and sexual assault. As an exception to the federal hearsay rule, prior inconsistent statements can be admitted for the truth when they're made under oath in a federal court. California is more liberal, and the statement can be admitted whether or not it was made under oath in California. Admissions by party opponents are allowed over hearsay objections, but where statements by agents, vicarious statements of the party, are admitted in federal court, they are inadmissible in California. Statements by co-conspirators are allowed in both systems, but bootstrapping, where the statement of the parties is used to establish a conspiracy between them, is not allowed in California. Statement of health for medical diagnosis, this is admitted in federal court, but restricted to minors in California. A statement of state of mind or health is only admissible in federal court when dealing with future plans, looking forward. Past statements of state of mind or physical condition are admissible in California where the declarant is unavailable and the statement concerns an ultimate issue in the case. Public records, activities of an agency, matters observed and factual findings are admissible in criminal cases in California, but restricted to civil cases in federal court. California, however, excludes opinions from such public records. So an FAA report on the cause of a plane crash would be inadmissible hearsay in California on grounds that it presents an opinion as opposed to facts. Statements in ancient documents are admissible when older than 20 years in federal courts, but 30 years is required in California, and they must have been acted on as true by an interested party in the case. Otherwise, these statements from ancient documents will be inadmissible as hearsay in California. Learned treatises are admissible in federal court, but limited to facts of general notoriety and interest in California. Where the federal rules have a catch-all exception allowing evidence with equivalent guarantees of trustworthiness, there is no such residuary exception in California. There are some differences in the hearsay exceptions in cases where the declarant is dead or unavailable. Former testimony offered against a person who was not party to the former proceeding is admissible in California where the prior party had a right and opportunity to cross-examine, but is restricted to situations where the current party is a successor in interest to the former party in the federal court. Where California is more liberal in dealing with former testimony, it's more restrictive in admitting dying declarations. Where the declarant must only believe he is dying under the federal rules, California requires the declarant to actually die before the statement made on the deathbed is admissible over hearsay objections. This is partly explained as the dying declaration exception is available in all civil and criminal actions in California, but is restricted to cases of criminal homicide in federal court. Where there are no equivalent federal rules, California allows out-of-court statements by minors describing child abuse or neglect, but this is restricted to criminal prosecutions where the child testifies or is unavailable and corroborating evidence exists to support the statements. The federal best evidence rule is replaced with the secondary evidence rule in California. Secondary, non-original evidence is admissible in California court unless there's a genuine dispute over material terms of a writing or its admission would be unfair. Oral testimony of the content of a writing is admissible in California only if the original or copy has been lost or destroyed in good faith, or if the evidence is not controlling to the outcome of the case and the cost or time involved in obtaining the writing are excessive. Where the 5 Doebert factors are considered in federal court today before scientific evidence is admitted, California focuses on the 5th factor and requires the test to be generally accepted in the scientific community. Defendants often wish to produce the results of polygraph lie detector tests as evidence of innocence. Polygraph test results offered by the defendant are admitted in federal court if notice is provided to the state prosecutor, the state prosecutor has the opportunity to conduct similar tests, and the evidence is only to corroborate the defendant's testimony and defend against impeachment. Where this evidence is inadmissible in California, it has been found to satisfy the 5 Doebert factors and has been admitted in federal court.